where she works on criminal law reform and justice policy in India. Her research, her research focuses on criminal justice reform, sentencing policy, and evidence-based legal policy making. She is also pursuing a doctoral research examining violence and discrimination against sexual minorities, contributing to discussions on inclusivity and rights within the legal system. Through her work, she contributes to policy recommendations aimed at strengthening India's criminal justice framework. Speaking against the motion is Dr. Chirag Banyan from the Navi Patil School of Law, a legal academic with over a decade of experience in teaching, research, and institutional development in legal education. One of the founding faculty members at Maharashtra National Law University, Mumbai, and currently associated with Navi Patil School of Law, specializing in criminal law, arbitration, mediation, and alternative dispute resolution mechanisms. Actively involved in conducting training sessions and professional development programs for lawyers, judges, and corporate professionals. His work focuses on bridging legal theory with practical dispute resolution mechanisms. This debate will be moderated by Professor Dr. Debrati Holder, who will guide the discussion and ensure a fair and engaging exchange of ideas. She is a professor at Patil University and honorary managing director at the Center of Cyber Victim Counseling, an organization dedicated to supporting victims of cybercrime, a leading expert in cyber law, cyber victimology, gender rights, and digital safety. She has conducted extensive research and advocacy on online harassment, cyberbullying, and protection of vulnerable groups in digital spaces. She is a recipient of several recognitions, again, including the Web Wonder Woman Award by the Government of India for her contributions to digital empowerment and cyber safety. We are also privileged to have an esteemed jury panel consisting of Professor V.V. Pandey, a distinguished scholar in criminal law, criminology, and human rights, associated with the National Law University, Delhi. Previously serving as a faculty member at Delhi University and held the NHRC chair on human rights. He is known for his extensive research on penal law, criminal justice reforms, and sociological perspectives on punishment. His work has significantly influenced academic discourse and policy discussions on criminal justice in India. Professor Dr. Mehraj Uddin Mir, who is a former Vice Chancellor of the Central University of Kashmir and a renowned scholar in criminal law and criminology. He has more than 4 decades of academic experience in teaching, research, and university administration. He is an author of several books and research publications on criminal justice and legal studies. Professor Dr. Arvind Tiwari, who is the Dean of School of Law, Rights and Constitutional Governance at Tata Institute of Social Sciences, Mumbai, with over 35 years of academic experience, a respected scholar in criminology, victimology, police studies, and access to justice. He has led numerous national research projects and training programs for policy officers, judges, and criminal justice professionals. His work focuses on strengthening human rights protections and improving justice delivery systems in India. Professor Dr. Purvi Pokhariya, who is a Dean at School of Law, Forensic Justice and Policy Studies and Director at LNJN, NICFS and NFSU Delhi. With over 25 years of experience, her work focuses on criminal justice, forensic science, cyber law, and AI in India. She is a former chairperson of the Indian Society of Criminology. Lastly, Dr. Raju Narayan Swamy, IAS. He is an officer of the Kerala Cadre. Dr. Swamy is known for his strong anti-corruption stance and administrative leadership. He currently serves as Principal Secretary in Parliamentary Affairs Department and Chairman of the Coconut Development Board. He is also an accomplished author and recipient of the Satyendra K. Dubey Memorial Award for Integrity. I'd like to now invite all the panelists and jury members to please take their seats on the dais. Right. I now invite Professor Devrati Holder to kindly begin the debate.
Very good afternoon to all of you. So there are several offensive behaviors for which the criminal laws in India have prescribed punishments, which include, for example, adolescent emotional behavior like love affairs between the adolescents, etc. Drug and narcotics consumption, then same-sex behaviors, motor vehicle rage cases, nuisances for any sort of cases like including road rages or any other things, and also on online cyber behavior. So theoretically, punishment should be prescribed on the basis of harm that may be quantifiable. But this has been misunderstood, misinterpreted in many cases. So today's debate is to understand whether India has a problem of over-criminalization, and if so, what can be the solution. We have eminent panel of juries, Professor B.B. Pandey sir, Professor Mehrad sir, and also Professor Abhit Tiwari sir. I can't see him in the seat, so if he's there, kindly come over. And also we have got other members of the jury who are not here, but I would request all of them to come over here. We have got motions by Ms. Ayushi from Vidhi Center and also Professor Dr. Chirag sir. So I would invite first Ayushi, every So first, Ayushi will be coming over. 20 to 25 minutes would be given as per the time schedule has been given to me. So we will be maintaining the time schedule, and after Ayushi, Professor Chirag will be coming over, and thereafter again 2 minutes will be given to Ayushi for the rebuttal. And thereafter we have got the jury's comments also.
Thank you so much for having me here. I don't think I take 20-25 minutes. I think 10 minutes should be enough. But so I'll be speaking for the motion that there is a problem of over-criminalization in India. So let me begin with a very simple question. What does it take to become a criminal in India? Do you have to commit murder? Do you have to commit fraud? Do you have to assault someone? Not necessarily. You could become a criminal for one, jumping a red light, not giving your dog reasonable exercise, as absurd as it may sound, or doing plumbing work without a license. Now, all these contraventions fall within the same legal category, that is criminal offences. This is exactly what I mean when I talk about over-criminalization. Now, criminal law is one of the harshest tools that a state has. It allows the state to arrest you, prosecute you, and take away something that is very essential for every human being, which is human liberty. Because of this immense power, criminal law has traditionally been understood to be as an instrument of last resort, something that the state should only use when absolutely necessary. But when criminal law is used to punish conduct that does not threaten life, liberty, property, public security, national security, which is already a very broad category in itself, it leads to over-criminalization. Of course, offences like murder, it directly harms life, and fraud undermines property rights and should be criminalized. These are precisely the kinds of harm criminal law is meant to address. But what fundamental value is threatened when someone fails to furnish documents on time? Or, hear me out, does not appoint a servant to pick up garbage? Even all of this is punishable under various central and state laws. Now, in India today, criminal law is increasingly used as a tool of ensuring compliance and almost everything and anything like the examples that I just quoted above. Now, to understand why this is a serious problem, we are going to look at three things in the next 10 minutes. One is the scale of criminalization in India. Two, the nature of the conduct being criminalized. And three, the way the punishments are prescribed within these offences. And together, this will establish not only that there is a problem of over-criminalization in India, but how large and absurd it is. Starting with the scale of criminalization in India. If we look at union laws alone, the numbers are shocking. India currently has 882 central laws in force. Out of these, 370 union laws have criminal provisions. Now, these are just numbers, may not mean anything, but here is the important point. Out of these 370 criminal laws, only about 25% of the laws are actual core criminal justice laws. Laws that one would normally expect to have criminal provisions. The Bharatiya Nyaya Sanhita, POCSO, Army Act, UAPA, etc. Now the remaining 75% of laws contain criminal provisions but regulate areas that are primarily civil or administrative in nature. These may include but are not limited to taxation, education, municipal governance, business relations, and personal laws. In other words, criminal law is no longer confined to address serious wrongdoing as it traditionally used to be. It has become deeply embedded in our governance structure, in how we govern everyday economic and administrative activity. Now, coming back to the numbers, across these 370 laws, we have around 7,300 criminal offences, 305 criminal offences. This basically means the state has 7,305 ways in which they can prosecute. Out of these, 5,333 offences are punishable with jail terms. Now, these jail terms may range from an imprisonment of 24 hours or to an imprisonment of 20 years. Out of these 5,333 offences, over 2,000 offences carry imprisonment of term over 5 years. And 301 offences are punishable with a death penalty. Now, there are other statistics that I can quote: how many offences are punishable with mandatory minimums, how many offences are punishable with life imprisonment. This just substantiates the point that yes, there is a problem of over-criminalization. Now, the number that I just quoted means that thousands of actions in India, many of them involving regulatory or procedural violations, can legally result in a person being sent to jail. These numbers alone show that criminal law is far more pervasive than we often assume. But the problem becomes even more clearer when we examine what exactly are we criminalizing, what is the nature of these offences. Now let me be clear, I am not trying to argue that criminal law should never be used outside the traditional crimes. There are of course situations where criminal sanctions are clearly justified. For instance, if someone deliberately evades taxes to defraud the government, you need criminal punishment to regulate people. Or if someone knowingly sells unsafe food, unsafe drugs, you need criminalization to ensure compliance. In such cases, the conduct here has a serious harm which is identifiable, there's deception or there's intentional wrongdoing. But the problem arises when criminal law becomes the default tool for ensuring regulatory compliance rather than punishing serious wrongdoing. Now, do we seriously need criminal law to ensure that animals are not tied on the road, or that no one performs plumbing work without a plumbing license, or nobody milks a cow on the road? Now, they may very well be legitimate regulatory concerns. You need to ensure that people don't do it. You need rules, inspections, and administrative penalties. But do they justify the full force of the criminal justice system? Do they justify arrest, prosecution, and imprisonment? I don't think so. When criminal law is used to enforce routine regulatory compliance, it loses its intended purpose, which is to punish serious wrongdoing. Instead of being reserved for serious wrongdoing, as I said, criminal law becomes a general compliance governance mechanism. And when every regulatory failure becomes a potential crime, ordinary citizens and businesses are constantly exposed to criminal liability for minor violations. They may not even know that compliances like this exist, but they can land up in jail. Now, in fact, we criminalize to such an extent that we started relying on general contravention clauses. That is, provisions that effectively criminalize any violation within the legislation. Let me illustrate this with an example. Section 108 of the Mental Health Care Act says, any person who violates any provision, rules or regulation provided in the Act shall be punishable with imprisonment up to 6 months or a fine of rupees 10,000. Now, this is the only criminal provision that the Act has. Now, what this does is, it's very simple but extremely problematic. The Act has a slew of provisions and compliances. It punishes failing to maintain books of accounts, which is one. But through the same provision, it also punishes performing a psychosurgery without taking consent of the patient and the board. Now, the gravity of both the offences is very different, but we're trying to punish both the conduct through the same punishment, which is imprisonment and fine. Now, this I'm giving this as an example from a very particular legislation, but across the 370 laws that we have, around 112 laws have provisions like this, general contraventions. Now, this is a classic system of over and arbitrary criminalization. The problem becomes even more complicated when we look at how these offences are punished. There are multiple instances where vastly different conduct attract same punishments. For example, jumping a red light can land you in prison for 1 year. And so does unlawfully compelling someone to work against their will, which in simple words is forced labor. So you're basically punishing jumping a red light and forced labor with the same amount of punishment, which is 1 year of imprisonment. On the other hand, there could be very similar conduct being punished very differently. The example that I quoted yesterday was buying a child for prostitution and selling a child for prostitution. Both are equally heinous offences. One is punishable with an imprisonment of 10 years. The other is punishable with imprisonment of 14 years. Now, one cannot understand why is there a difference between the two. Now, some might argue why this matters. These offences are hardly enforced. But the argument misses the point. Even if rarely enforced, these criminal provisions matter. They shape one, the power of the state, two, the risk citizen face, and three, the culture of governance. It shapes the relationship between the state and the citizens. When the law makes thousands of actions criminal, ordinary citizens can unknowingly fall into criminal liability. And once criminal law is triggered, the consequences, as we all know, are severe: arrest, prosecution, loss of liberty, and social stigma that follows loss of liberty. Now, that is why I argue that criminal law should be used sparingly and carefully. And now I would like to close by saying that criminal law, of course, represents the most coercive power of the state. It allows the state to take something very fundamental, that is human liberty. And therefore, such power must be exercised with restraint, clarity, and a clear purpose. But today, India's criminal law landscape, as I just said, tells a very different story. We have thousands of criminal offences, hundreds of laws that creates crime, many targeting minor regulatory behavior, very minor regulatory behavior. I would like to give an example of municipal laws, the NDMC Act, the Maharashtra Municipal Corporation Act, the Mumbai Municipal Corporation Act, individually have over 4,000 crimes. Now, this may range from something like rioting under the Delhi Police Act, but would also cover not throwing your garbage, not taking a plumbing license, etc. Now, I think recognizing the problem is the first step towards fixing it, because when criminal law is overused, justice is not strengthened, it is weakened. For these reasons, I strongly support the motion that yes, there is a serious problem of over-criminalization in India. Thank you.
Thank you, Ayushi, for presenting her views within time and so beautifully. Now I invite Dr. Chirag to present his presentation.
A very good afternoon, everyone. I have taken an uphill task of defending over-criminalization, though throughout my work in criminal law, including this volume, I have propounded a theory how to prevent over-criminalization. So the idea was we should frame it as a debate rather than pursue it as our personal opinion, because there are always two sides to a coin. So does this particular motion. Does India have a problem of over-criminalization? First of all, I would like to question the framing of the motion itself. Problem of over-criminalization, it is trying to imply that even if we accept what she's saying, that there is excessive criminalization, it is problematic. I think we need to clearly establish in what way it is problematic. Because once we say it is problematic, we are going in a direction that there are systematic issues with our criminal justice system which is resulting into affecting the rights of the individual, liberties getting curtailed. So I think we need to bring out those systematic issues if we want to frame it as a problem of overcriminalization. My second probably disagreement would be the framing of the word over-criminalization. How do we define over-criminalization? See, legislature performs its function, it enacts a criminal law, which is within its plenary power. It is well within the power of the legislature to create criminal law, to provide punishment. When does that become over? Does that become over? And she would like to believe us because we have too many criminal laws. She gave us starting number which might create a confusion in someone's mind. Oh, we have so many criminal laws, but there are so many studies which says just more number of criminal laws does not mean that it is over criminalization. We need to look at qualitative nature of the criminalization and not just the number, because we have to contextualize the number in light of the size of our democracy, in light of the size of our entire legal infrastructure. Criminal law was envisaged in the era of a police state. Then we became a welfare state. And after developments like 2611 in India and 911 in America, we have moved toward a preventive state. So when a state exercises its preventive powers, preventive function, which might result into constraining of liberty of individual, should we necessarily say that criminal law has been used in a wrong way? Yes, state had to provide for these kind of situations because this is the evolving role of the state. Now, should we judge the criminal law based on the traditional notion of the police state, or should we adapt our theories? Should we rethink the architecture of the criminal law, considering the contemporary developments which have happened, the requirements of the society? We also need to keep in mind that our constitution is very different. The framing of over-criminalization comes from the work of Douglas Hurst, Anthony Duff, then Andrew Ashworth, Joy Feinberg, and there are so many philosophers. But it is primarily a Western framing over-criminalization. If we look at our constitution, it is not like Western constitution. Our constitution Part 3 has two parts to it. Generally, Part 3 is considered as restriction on the powers of the state. Means if the state has done something, then that can be challenged on the ground of equality, on the ground of Article 19, Article 21 violation. But our constitution also prescribes state to take some active measures to protect women, to protect child labor, to protect trafficking, and to protect many other things. So our constitution also tend to equalize the society. So it is the mandate of our society to create criminalization, which, as Ayushi would like to believe, does not fall in the core of the criminal law. Anyway, who decides what is the core of the criminal law? Should we decide the core based on the traditional harm principle which was given by J.S. Mill? And even the Western thinkers like Feinberg have abandoned John Stuart Mill. They have advanced the harm principle in so many ways that it had been construed in a way which was not considered in the past. So, for an example, we required physical harm in the past. Now, in an age of social media, the harm could be caused in a way which does not require physical contact, but still the harm is caused. So, should we not consider the evolving nature of the harm? Then Ayushi also mentioned something about before I comment on that, I want to emphasize that the criminal law provides punishment. Agreeable. It is a formal tool and the most lethal tool in the armory of the state. That is also agreeable. It is exacting. right? It has serious implication. But merely because it is exacting does not mean it is problematic also. It becomes problematic when there is also a problem of people going to jail in large number. If we look at most of the offences which you have cited, there is hardly any enforcement of those laws. Most of those laws just remain in the textbook. Now, she construed it as, or she portrayed it as, there is a possibility that there could be a misuse of the power that, and in her word, that changes the relationship between the state and citizen. But if it is not enforced at all, people are not aware, does it really create a problem of over-criminalization? To me, then it's not the framing of over-criminalization, it's a framing of under-criminalization. In fact, that is the fundamental nature of our society. You go to the police station, FIR is not getting filed. Arrests are not properly made. Yes, there are pre-trial detention, but in my research I have found usually people get bail after 1 month of the detention, and then the trial prolongs for years and years, and even then the conviction rate is 20%. So if we are not able to enforce this criminal law, if we are not able to even deter the core of the criminal law, should we frame it as over-criminalization or should we frame it as under-criminalization? So over-criminalization, under-criminalization, and then how can we forget about decriminalization? So many laws by the present government has been decriminalized. There are more than 2,000 laws which, according to the recommendation of the Law Commission report, has been decriminalized. More than 60 offences under Companies Act, which he mentioned as regulatory crimes, have been decriminalized. Jan Vishwas Act, which intends to introduce not ease of business, not just ease of business, but ease of living, has also decriminalized hundreds of offences. So again, and this is where I take it to the point that how it is a problem of over-criminalization, it becomes problematic if it is a systematic issue. But what we see in a past decade or so, there is a systematic attempt to reduce the criminal laws and to reduce the intervention of the criminal law. Another reason why we call a criminal law to be a criminal law is because it has the colonial legacies. And yesterday we had a wonderful speech by the Honorable Minister, who himself mentioned that we have, from IPC to Bharatiya Nyaya Sanhita, we have changed the framing from punishment to Nyaya, from penal to Nyaya. Indian Penal Code to Bharatiya Nyaya Sanhita. I think that is what tells the mindset of the state, that the purpose of the criminal law, the core ideology of the criminal law, should not be to punish, but should be to offer justice to the people. And at the end of the day, whether something is a serious wrongdoing or a less serious wrongdoing cannot be decided that if it's not murder, if it's not theft, it's not rape, it's not serious enough. Say for an example, she gave an example of leaving astray a cow on the street, which is very dangerous. There are so many accidents which are happening on the highways, and there are so many people who are getting killed because of stray animals on the street. Likewise, if you take an example of motor vehicle act, illegal parking, there is an ambulance which has to cross, but it cannot cross because of the illegal parking. And there are so many again. So, how do we frame again the seriousness? Should we frame the seriousness from the perspective of the liberty, or should we frame the seriousness based on the perspective of its impact on the society? These things, while they may sound to be very minimal in terms of very, the word is minuscule, they might sound to be very minuscule, but they have a very high impact. Jumping a signal, so many accidents happen by jumping a signal. Now she may say it is a paternalistic state, but paternalistic state has never been considered equivalent to over-criminalization, because for over-criminalization we have a hypothesis that there is some normative baseline of criminal law. But there is a work by, again, Anthony Duff has published 5 volumes on over-criminalization, and after spending millions of rupees on that, in the final volume, they write, finding a normative theory is not possible. So this is what the conclusion is. Not a single philosopher in last 3-4 decades on the work of overcriminalization has been able to find what is the normative line beyond which we call it is overcriminalization. They have come to the point that it has become a new reality of the state. Even if we look at the work of Andrew Ashworth and Lucia Zedner titled as Preventive Justice, they have said all the preventive powers are justified as far as there is proportionality and there is necessity. So, just merely because there are preventive powers, a person could be detained on the basis of dangerous and risk does not necessarily mean that it's a bad law. What is required is wise judicial discretion, and that's where I again would like to disagree with her, wherein she compared various provisions that for jumping a signal it's 1 year, and for another offence she mentioned forced labor is also 1 year. But at the end, the wise discretion lies in the hand of the judges. They look at the profile of the person, they look at in what manner that activity has been done, and it is not necessary. If it is up to 6 months, they can always give the punishment of rise before sunset. That is possible, or maybe 1 day of punishment today. We need to show by data if we want to claim over criminalization, even though there is imprisonment, how many times judges have actually exercised their discretion in favor of imprisonment. So, with this, thank you. I conclude by saying that we do not have a problem of, again, over criminalization. It cannot be casted as a problem. We do have criminalization, we do have more number of criminal laws, but that is not necessarily they are excessive in the sense as we traditionally understand. And I think I must stop because I am keep getting more and more arguments and I keep speaking. So I think in the interest of time, I'll speak. Thank you. I'll stop.
I'll just quickly address 2-3 points and I'll keep it very brief. So when you say that it cannot be called a problem of over-criminalization, because what then is under criminalization? So let's frame it as unprincipled criminalization. Because when we say there's a problem of over-criminalization, we mean that criminal law is being used for purposes that it is not meant for, right? For you to ensure that I take a license, the state doesn't need imprisonment as a threat. The state is now trying to move towards trust-based governance, right? That is why we have these Jan Vishwases coming in at the central level, at the state level. So idea is to facilitate compliance and not coerce people into complying. And that is why when we say, yes, it does frame, it just changes citizen-state relationship, because then the citizens see the state with I don't know, apprehension, fear, because you're always under the threat of going to jail for something that you may unknowingly commit. Now, when we talk about numbers, I would like to clarify that it's not about the numbers, it's about what we are criminalizing. So, BNS has a lot of offences, and IPC had a lot of offences, but there was a clear logic to what these offences are. There was a clear flow in the statute book, and we keep on saying that traditional law is bad, but I would say IPC was very clear with what it was doing. It had a clear, the IPC was intended to protect fundamental values of life, liberty, property, national security, and ensure public order. And that is what criminal law should do. You shouldn't need criminal law for minor things like whether you have appointed a servant or not to collect garbage or dust. It's not the state's job. The best that the state can do is facilitate all these compliances. Now, when we talk about what we are criminalizing, there are around 250 offences which criminalize failing to file documents. Now, it's not about the numbers. It's about the fact that we are criminalizing failing to file documents. It's not even failing to file documents intentionally, failing to file documents with an intent to defraud the government, it's just failing to file documents. We also criminalize failing to maintain accounts. Now, for something, let's say under the Income Tax Act, CGST Act, something like this would make sense because the very purpose is to ensure that there's fiscal responsibility and the state is meant to take taxes from you. But for other legislations, it doesn't make sense. Now, when you talk about the preventive power, yes, I would say it is a very paternalistic approach. We have to move from prevention to facilitation, and this is exactly what the state is trying to do. The state is trying to decriminalize this because there is an acknowledgement that there is a problem of over-criminalization in India. Who decides the core, you asked? Who decides what is principled and what is not principled? Who decides what should be criminal, what should not be criminal? I think this is exactly what the lawmaker's job is. You're making laws, you're drafting laws, you're creating new criminal offences with each passing day. You've been sent to the parliament to do this job. You have to decide what offences cause harm, what has a clear and direct possibility of harm, whether criminalization is an effective and efficient solution or not, and whether the punishment that you're prescribing is proportionate or not. Of course, judicial discretion is important, and we of course have that in a lot of laws, in all laws, but the law is supposed to guide this judicial discretion, right? A lot of laws have mandatory minimum terms of imprisonment, where even the judges cannot acquit the offender because there is not enough evidence to provide such harsh punishment. And I mean, it's a problem that has been well acknowledged. So yeah, I mean, this is about it. Another point that I would like to say is we resort to criminalization because we see it as the only option that we have. State sees criminalization as the only effective solution to everything. We lack innovative thinking at the state level to figure out alternatives to criminalization. For instance, not following the conditions of a license, you not need imprisonment for that. Cancellation of license works equally well because that would be much more deterrent than sending somebody to jail or imposition of fine. That's about it.
Nowadays for the juries, please. Whatever you have already rated them or anything you would like to do.
I think both of them have very compellingly argued on the issue. One says that there is over-criminalization, and the other says there is less of it. The second viewpoint is supported by the Constitution, by the change in the form of the government and the nature of regulatory states emerging and prevention of crimes as the objective, all very laudable. But one has got to understand what involves criminalization and why criminalization is bad. Criminalization gives to the state power to rob certain guaranteed liberties to the wrongdoer. It permits the state to send him to prison, and it entails a lot of stigma, social stigma, not only to the wrongdoer, even to the family. Stigmatization is there. Therefore, all the wisdom, I recall a wonderful article by Professor Andrew Ashworth, Is Criminal Law a Lost Cause? He wrote this article. Andrew Ashworth is one of the celebrated criminal law teachers of England. In 2000, Law Quarterly Review, it's a 50-page article, long article. Is criminal law a lost cause? And his reasons for doing that is the indiscriminate growth of crimes, criminal law in England, almost 8,000 offences. And many civil wrongs were converted into crimes by using hybrid procedure. In the end, he comes to a conclusion that this over-criminalization is ultimately leading to a kind of unprincipled criminalization. Criminal law of England can still be saved if the following four principles are kept in mind. That only for serious wrongdoings, criminalization should be there. And so, 2, 3, 4. Now we are talking of our society. And when we are talking of over-criminalization, you must also remember the very wise words, I would say, of a conflict criminologist, Stephen Box, in Crime, Power and Mystification, his book. Unfortunately, Stephen Box died early. He said about crime, too many of us for too long have believed crime and have seen crime from the eyes of the state. Because state enjoys a monopoly in criminalization. There might be certain behaviors that might qualify to be, but they are not the behaviors which are in the eyes of the state. I, for one, have been doing in my paper that is with Gerard, and you also have it, Tiwari Sahib, in which I have said it is not only unprincipled criminalization in India, it is contested principled criminalization. And 3 instances of contested principled criminalization are, first category is speech crimes. Dissenting speech in Maharashtra, there is a legislation. These are people, urban Naxals. Therefore, we are making it law. Same in Karnataka. There are urban Naxals in Karnataka also, in Maharashtra also. And they are speech crimes. You are expressing, airing freedom of speech, which is a constitutionally guaranteed right, but you make it a crime. Similar second category of crime, contestable, is land and property crimes. Land user and property user crimes. In Gujarat, in 2006, a law was made that certain localities will be reserved for a kind of apartheid, minority communities. And the same has been now, bill has come in Rajasthan, based on certain communal considerations, which are contestable principle criminalization. They have not gone to the court, all of them need not go to the court, but their impact in the society is profound. The impact that occurred in South Africa of apartheid law, we are creating a kind of plethora of apartheid laws. Certain people will not go to certain area, certain people will not live in certain area, making an assumption that communities cannot live together. Communities which have lived together for generations. are being told on certain policy considerations. The third category, which is contestable, is a spin-off of love jihad. And the progeny of this has been much more prolific. Anti-conversion laws in almost all states, starting with UP, Uttarakhand, other states. 9 states have anti-conversion laws. And some of the states have recently, for a crime of anti-conversion, punishment up to life imprisonment, 20 years ago. A serious crime. And the last one in the whole episode is interfaith marriages or restrictions put on them. Uniform Civil Code in Uttarakhand, registration of marriage is compulsory and it is an offense if you do not register that. Now, these are crimes. Live-in relationship is being criminalized. वो बहुत डेंजरस चीज है लिव इन रिलेशन एक लड़का एक लड़की साथ रह रहे हैं ये कितनी भयानक चीज है एक लड़का एक लड़की साथ रह रहे हैं दोनों मेजर है they have freedom to live the way they like you have no one to interfere recent proposal to Gujarat law on marriage is that guardians of adult children have to give consent for the marriage. नहीं तो 22 साल का लड़का 20 साल की लड़की कैसे डिसाइड कर सकते हैं शादी करेंगे वो तो माता पिता की परमिशन लो otherwise it will be an offense. Now what kind of society you want to control the lives of young people create a crime young people are more dangerous. They get married, they love. उसी का रीजन है भारतीय न्याय संहिता में सेक्शन 69 ऐड कर दिया गया मैरिड वुमन 63 में नॉन कंसेंसुअल सेक्स बाय हस्बैंड is no offense if the wife is above 18 years old. But if you promise a girlfriend's right is better protected than 10 years imprisonment. प्रेम करने पर बहुत कंट्रोल रखना है प्रेम करने वाले ही समाज को समाज नुकसान कर जाते हैं दिस काइंड ऑफ सब जगह औरतों को ही कंट्रोल में रखो गार्जियन की परमिशन के लिए bring control over women of youth has to be controlled. Now, these are instances of over-criminalization. Not on principle criminalization, but new things in the field of over-criminalization. Therefore, Chirag, we have got to think deeply, and I think your 2025 report has at page 1 introduction portion में उन्होंने इनकी विधि सेंटर की 2025 की एक रिपोर्ट आई है स्टेट ऑफ स्टेट उसमें उन्होंने कहा है इसका कंसिक्वेंस क्या हो रहा है इंडिविजुअल फ्रीडम स्टिफल हो रही है इकोनॉमिक इनिशिएटिव थॉट हो रहा है गवर्नमेंट इज लूजिंग ट्रस्ट इन द रूल्ड and ruled are losing trust in the government. इसका consequence ये हुआ. Better would have been Jan Vishwas model, where selective decriminalization. Jan Vishwas 23 वाले को भी मैं agree नहीं करता हूँ, क्योंकि it is only to ease business. Marginalized तो business नहीं कर रहे हैं. उनके लिए ease करने का कोई इंतजाम करो. Do something for them. Large section of marginalized. You have cared for the business doing class. but there are other classes also in the society. So you should have taken up the task, the same line, decriminalization in all areas selectively, and bring community in the definition of crime, in the process of criminalization. Don't make it a state monopoly only. Thank you very much.
Thank you very much, Julie. So, Chirag sir, uh, should we, Purvi ma'am, if you would like to share anything.
So, good afternoon all. It's a very nice proposition to hear Ayushi, my former colleague, and Dr. Chirag. The question of over-criminalization that has been discussing, we have been discussing this issue for quite a long time. But Professor Pandey, I just would like to go to the root of this thing. One thing is over-criminalization, and Ayushi's report that has been very well articulated. And you've given all kind of instances. But the one thing we have to also do as a part of the further follow-up research is that, one is over-criminalization and one is the practiced over-criminalization. In a sense that all the provisions which we have been discussing about, that this is something which has been laid down as an over-criminalization provision under the different laws, but what has been actually happened in this case? How many people have been already sent to jail for 1 year or for 6 months for these kind of offences? So, sir, I really feel that we are struggling with, as of now, the nationalism of Tagore and Ambedkar. Because on one side, we have been considered as a security state, the security concerns of the state has been rising. We have been becoming more and more paternalistic society, and that kind of I would say the kind of power, or the power in the name of the care and concern over the citizen that we try to portray through different policies and legislation is not only with India, but I would probably say that in number of other countries that is been rising. So somewhere we need to go to the root of this particular concern, that why it is happening. Probably I just would like to discuss over here is that when we talk about over-criminalization or under-criminalization or principal criminalization, these all have been the part of our theoretical discussions under the academic groups. We all have been we all witnessed the recent making of the new criminal laws. Now, even it is not being called as a new criminal laws, now it's called is न्याय की नई संहिताएं, because the word again we use the criminal law, which is not appropriate because the whole idea is to have justice in our central theme. So, sir, we all know that, and we have seen in number of reports, the academicians were the core in the beginning of framing this entire report of the new criminal laws. So, in all this making the entire report of the new criminal law, the criminal law amendment, how far we have adopted the principled criminalization in our report. The report is not available publicly, but then those who are the part of the report, they are quite well aware of. So, I mean, according to me, when Dr. Chirag talked about the over-criminalization and challenged the definition of over-criminalization, how do we define the over-criminalization? Because it's all about the perception, it's all about the society. So, the law-making process is always very contextual with reference to the society, the culture, the way in which it is getting evolved. So it would be always very subjective term, and then especially when the paternalistic approach of the state has been rising, and that happens with the kind of I would say the what Professor Bakshi used to say, the demonstrudence, the way in which this new way of demonstrudence is being evolving. So there are number of undercurrent of with reference to the over-criminalization. So I believe that unless and until as a society we evolve, I just give the simple example. We all know there are, if you go to the other developed nations, in an ordinary case, we have witnessed, I mean, it's nothing to demeaning Indians or Indian diaspora, but then we have seen that, in the other developed countries, in the ordinary sense, people are honest in their approach. But then, I don't want to really condemn, but in reality, in our case, in most of the times, and not only as the people, but as someone, the part of the someone who is governing, they also believe what the people say. But at our place, everything starts with a distrust. So there are a lot of cultural connotations with reference to the lawmaking process, and we should not rule out this lawmaking process. And as of now, the diverse nationalism is dying. That what we have been observing. And then somewhere the kind of a new nationalism which is evolving is more focusing on the security of the states and the popular when we have the majoritarian approach. So we need to have somewhere something to have a counter majoritarian tool, which we do not have as of now. So I mean to say that, just because of laying down the provisions of the law XYZ legislations, we cannot say criminalization. I mean over criminalization or under criminalizations. There are a lot of contributing factors and the context that we have to consider. Thank you.
Well, I take only 1 minute. In fact, I feel as a member of the jury, both have made an excellent presentations and have tried their best to make their point of view. Well, Professor Pandey and Professor Purvi, they have also raised certain issues. And Professor Pandey is right. Say, when we talk about our criminalization, you may talk of love job, you may talk of bigamy, you may talk of compulsory registration of the marriages, some private issues. Well, my problem is, you see, the crime is a dynamic, society is a dynamic, so is the crime. Every time, every now and then, the concept of crime is changing. What may be crime today may not be a crime tomorrow. Or what was a crime yesterday may not be a crime today. And thereby, with the dynamics of the crime, criminalization is also part of the society. But at the same time, as I said, I will take just 1 minute. We have to avoid over criminalization. The criminalization has to take a part, has to be a part of the society, progressive society, developing society. But this should be a principal type of criminalization. Well, I am not in favor of over criminalization, and also I am not in favor of decriminalization, which is not within the parameters set by the society. Here, I, as an old person, I am guided by both very old two cases. I think all of you have read it when you have discussed Pennsylvania. R versus Tolson and R versus Bernice. In one case, the acquittal was given. In the other case, conviction was required. And the distinction which was laid by the House of Lords was that of, if I am correct, because very old case, Malam Insi and Malam Prajja. And whatever was from Episho, not wrong, that was regarded as punishable. What has been made by the statute was not made, conviction was not given. We must not ignore, while criminalizing, while making any act as a crime, so far as our basic moral values are concerned. As on date, there is a hell of difference between what is immoral and what is crime. Our lawmakers do not keep their eye so far as our moral values of ancient India, of present India, of our societies. India does not mean Mumbai, Delhi, or Madras. India, you know, is a very vast and diverse country. You have different cultures. Well, when I say I am also against decriminalization, take the example of adult. I think no society in India, even in this modern India, will accept that any female member of his family will indulge in what we call adultery, so far as our families are concerned. Thereby, our law-making people, our judiciary, while interpreting all these issues, must keep an eye what are the basic norms of our society, and this will, I think, in my opinion, guide both, whether we talk about our criminalization or we talk of what we call decriminalization. But in any case, the criminalization will continue with the growth of society. Thank you.
Hello, sir. Can I say, sir? Yeah. Okay. Good afternoon. I'll not repeat whatever has been said by other colleagues. Professor Mir has also said whatever I wanted to say. Few things like, for example, see the social order and law-abiding behavior. If we see the societal changes nowadays which is happening. For example, we are giving, because we are maturing as a democracy, so we are overemphasized to the rights. We should be, because those are conferred by the Constitution to all of us. Are we equally sensitive towards discharging of our responsibilities or duties and surrendering the Constitution? Perhaps I feel there is a gap. So the both kind of argument which has been given by Ayushi and Dr. Chirag, I also find myself in between. That yes, in some kind of areas there is little over criminalization, but also it is not that we do not bring behavior, because for example if you see like I have little different opinion level living relationship, fine. I mean we all are adult after 18 years of this thing, but see the pattern of crime which is happening out of that, and social, what are the social realities? Can we think of that? Marriage life, yes, there are problems, violence is there, evidences are there, but it still gives some kind of social sanctity and some sort of responsibility to all of us to abide the social behavior and therefore not to indulge in unethical kind of practices. But here, in living relationship, person is free. Today we are together, tomorrow we are out of the scene, but the kind of pattern of crime which is emerging. So what I feel, there is a need to have a balance. Yes, we need decriminalization of certain kind of offences which are outdated in today's context, but at the same time, we should also evolve a culture of law-abiding behavior. For example, if you see a traffic violation, if there is no constable, the things would be different. So I feel that there is a need to use the provision of Habitat Act and other kind of modes for lessen the punishment and give more opportunity for community service kind of things. But I think both aspects have to be taken care of. So I feel that over-criminalization in some offences, but also it is not that we don't need the criminalization. We need the criminalization, as has been said, the principal criminalization, looking into the social and cultural realities of the society. Thank you.
So, thank you for this wonderful debate, and it has given a lot of food for thought for Professor Pandey's interjection particularly. In my opinion, there are two things that when we talk about this issue. One is the question of bad laws, and the second is the question of bad implementation. I'll give just two small examples. When we talk about bad laws, one is the beggary laws, which criminalize begging. There's section 122 of Bombay Police Act, which criminalizes moving around in suspicious circumstances. And the interpretation is that after sunset. And the discretion is with the police officer, what is the definition of suspicious circumstances. Bad law, I'll give an example. A woman who was mentally disturbed got into a cab and she roamed the city of Mumbai and she didn't pay the fare. The taxiwala took her to the police station. Police charged her with theft and put her, and she was in prison. And the case took long, and I don't want to get into the story. This is the classic example of bad implementation. Anybody could have made out that she is a person mentally disturbed and should have actually been sent for treatment in a psychiatric care institution. Instead, a case was lodged against her and she was sent to jail. So, if both these aspects need to be looked at when we talk about this issue. Thank you.
I think that both the proposition that proposed by our Speaker IOC and Siraj, and after hearing my friend Professor Raghavan also, that two aspects I have to mention there. One is our issue of over-criminalization, as mentioned by Professor Pandey. We are observing more on some special legislation being done, rather than the comprehensive our law, either BNS or PPS, IPC. Some special legislation, criminal legislation. If we, our academics know that there are some era where the wrongs, some wrongs under civil liability, some wrongs are criminal liability, and the tendency is that some civil liability now being transferred to criminal liability. And as regards implementation, I refer to incidences and real case reported also. One is Supreme Court case on Shankar Das versus Union of India for parking by central government staff in the no parking area in Delhi South. That is conviction and loss of job also is reached to Supreme Court. Supreme Court observed or for others not thought of or no parking area, there would be a crime and the personal loss is so. So we have to look into the special legislations where we can divide the civil liability and criminal liability. And the other is I can refer to the victimization of the weaker section, particularly women. The excise law, our excise law, I have in my research I have seen that women for poverty, particularly the case reached to the court, that widow having only one daughter for earning, carrying illegal produced liquor from the village to town and being intervened and police sent to jail also. But the women not know that these are offences. So how we can deal with the situations, implementation, that for without minimum knowledge, though we know that ignorance of law is not there, but how we are punishing, who are punished. So that we have to think in our process of issue of criminalization or.
Thank you very much for all your inputs. I'm just thinking of what Dr. Bakshi once said at the very same criminology conference in Delhi. He said that with GDP we might not be on top, India as a country. When we look at GLP, gross legislative products, we would really be on top because we create so many laws. As we speak, there are laws being made. So that one, and another thing is I was reminded about a book by Dr. Navi Mumbai, which speaks about less law, more order. So I think this is what we need to do. We need to shift some of the cards around from the criminal justice to the social justice. So once that happens, I think there will be a balance and the criminalization would also be taken care of. So some points that you made was all social justice issues, not really criminal justice issues. Now we are overburdening the criminal justice system is what I think. Thank you.
I agree with what Rindu has said, that in United States, a large number of vagrancy laws were decriminalized and they became subject to medical care, social justice laws. Similarly, in India too, Mental Health Act, Section 115, we have been struggling for a long time in decriminalizing attempted suicide, Section 309. The Law Commission giving report and one after another, and we could not come to a conclusion. For 30 years or more, Supreme Court decisions, one after another, till the government found a medical, converting the problem of law and order into a medical health problem and made it Mental Health Act 2017, Section 115. A person who commits suicide is to be presumed to be under stress and made it a duty of the government to de-stress treatment. So, from being criminalized, he became entitled to a duty that came into the government's hands. Now, these could be instances that we have done it. We need not go to United States of America for decriminalizing. We have done it ourselves. Why can we not follow similar paths of decriminalization of many offences which continue, which still are part of DNS?
Sir, in this regard, I'd like to add that I think more than a decade ago, Section 109 CRPC, where you could, like the police could book anybody under suspicion. Yeah, yeah, and then it was decriminalized because then we were told that no, you can't like book anybody because he was found in suspicious circumstances. So what Professor Pandey, Professor Vyula Shekhar is saying is quite true that one can adopt this thing and there is a precedent. But my concern is also connected with what Professor Raghavan has said about the implementation part of it, and there is a lot of as an implementing agency or enforcement agency, there is a lot of stress happening at that level because there is a collision between the society and the state, and at the altar of this collision is the enforcement agency because they don't know how to handle certain situations. For example, and this I also would like to connect with the kind of social reform context in which this country has evolved. So, from emancipation and social reform movements, we have generated a lot of laws, very good laws, like for example, Bonded Labor Act, or for example, Child Marriage Act. These are acts which are basically reformist in their nature. They directly hit at the structure of the society and normative structure of the society, from which the normative structure of the society and how the normative structure of the society gets collided by the law in itself. But when you see the implementation, we should have serious studies seeing the implementation of Bonded Labor Act. And I am very sure 90% of the bonded labor incidences which happen don't get converted into the law, into the enforcement or. Similarly, I feel that other such laws, for example, Child Marriage Act. Now, Child Marriage Act, when we go and implement this law, we need the support of the civil society. Over the years of my practice as a police officer, enforcement officer, I have seen that when you try to apply social reform generated criminal law, you need the support of the community. If you don't get the support of the community, you can't simply interfere in the social context of life lived. There is a marriage happening, and like you go like a villain in that marriage and pull the child or the parent out. It doesn't work that way. So, but if there is a community support, you can do it. So we have been utilizing civil society to support that in this kind of manner. So the enforcement part of over-criminalization is also a very important part. Over-criminalization or not, but the proliferation of the criminal laws have to also be seen from the climate within which it is getting implemented. Now there is also politics of implementation. The politics of implementation is also based on the power dynamics of the local society and of the super society, whichever exists. So all these dynamisms of enforcement of criminal law is very important.
Thank you for all your inputs due to the time scarcity. Now we have to wrap up the session today, and thank you all the panelists and also the jury members, Pandey sir, Mehra sir, Arvind Tiwari sir, and also Purvi ma'am. And a huge round of applause for the debaters also for the wonderful presentation. Thank you so much.
Please remain seated as the felicitation ceremony will be taking place right after this. I'd like to thank all the dignitaries, panelists and participants. That concludes this portion of the conference. It is now my privilege to extend a warm welcome to our distinguished dignitaries through a felicitation ceremony. I would like to request the Director of the School of Law, Professor Dr. Karuna Akshay Mahavir ma'am, and the President of ISC, Professor Dr. N.K. Chakravarti, to please felicitate our dignitaries. And the Chairman of ISC, Mr. Madhavan sir. Beginning with
Why not apply now? Not getting what in this week. Yeah, but okay. Why 4? You can change it from there.
beginning with Justice Victoria Gowdy, Additional Judge of Madras High Court.
Remember on our school year?
Dr. Danaji Jadhav, Registrar, Maharashtra National Law University, Aurangabad. Dr. Purvi Pukharel, Dr. Garima Pal, Dr. Vineet Kapoor, Dr. Arvind Tiwari, Dr. Meenakshi Sinha, Professor B.B. Pandey, Dr. Upnit Lali, Dr. Kavita Singh, Professor Dr. Vijay Raghavan, Dr. Kiran Sharma, Dr. Keval Uke, Dr. Sistina, Dr. Garima Pal, that concludes this felicitation ceremony. Thank you to all the dignitaries. I would like to request all those